Good afternoon and welcome. On behalf of the National Catholic Educational Association, thank you for joining us for this professional development opportunity. I am Christy, facilitator for today's NCEA webinar, The Impact and Legacy of Pierce versus the Society of Sisters, 100 years later, 1925. What it was and why does it matter today? A few quick points before we begin. First, this session is being recorded and will be available on ncea.org through your membership portal. Next, the Q&A box is open and we value your input. Please submit questions and comments via the Q&A box and note that the chat is disabled. So the Q&A box is where all your feedback and engagement can live. Finally, stay with us. After today's presentation, we'll share a link to the survey and instructions for receiving your certificate of completion. We'll begin our time together today in prayer. Please join me in the name of the Father, and of the Son, and of the Holy Spirit. Amen. Heavenly Father, source of all wisdom and justice, we thank you for the gift of Catholic education and for the freedom entrusted to parents to guide their children in truth and faith. As we reflect on the history and legacy of Pierce versus Society of Sisters, grant us clarity of mind, strength of purpose, and a renewed commitment to defending the mission of Catholic schools. Bless our presenters and all gathered here today, that our work may serve your church and your people. We ask this through Christ our Lord. Amen. In the name of the Father, and of the Son, and of the Holy Spirit, amen. At this time, it is my privilege to introduce today's speakers. Dr. John James is a professor of educational administration at St. Louis University and editor of the Nesbeck's monograph series, published by NCEA. He also serves as editor for the Journal of Catholic Education and International Studies of Catholic Education. Welcome, Dr. James. John DeJack is director of the Secretariat of Catholic Education for the USCCB. An attorney, educator, and former U.S. Army officer, Twin Cities High School's co-editor of With God in America, and a member of the Fellowship of Catholic Scholars. Welcome, John DeJack. Gentlemen, thank you so much for being here with us today. The screen is yours.
Great, thanks, Christy. John, it's good to see you again. Looks like you made it home from St. Louis this last summer.
I did. It was fantastic. It was great to be there with you, and it was a wonderful conference back in May. So
awesome. Looks like you got a haircut too. I need to get one too. I got this little Bozo the Clown thing working right here. So
well, Christy had mentioned that I was in the Army. Now I keep the same haircut as just to even it out though, because there's not much left. So anyway, yeah.
Well, I'm right behind you there, brother. Well, let's go ahead and get started here. So first off, I want to talk about maybe the context for Pierce versus Society Sisters. And it's difficult for us to put our head around the 1920s and kind of the context of this country and Catholic education at the time. Right after World War I, there was an intense focus inward in the country. There was a focus on public education and a concern about anti-Americanism. There was a wave of isolationism that gripped the country as well. So in this kind of reactionary mode, as there was concern about Darwinism, the response to that was, well, let's have Bible readings in the public schools. When there was all these hyphenated people, well, let's get real anti-immigrant on that and prohibit foreign languages, particularly German. In fact, there's a Nebraska case that John might be talking about a little bit later on that point. And then, of course, concerned about the Bolsheviks. And if that's the case, then we need to be gravely concerned about who is teaching in our schools. All this kind of percolated in terms of the rise of the Ku Klux Klan. Now, we oftentimes associate the Ku Klux Klan as being concentrated in the South and primarily focused on African Americans. And that certainly is true, but they also had a very specific ire against Catholics. And all this fed into good old-fashioned bigotry against Catholics. What we fail to realize is that the KKK at that time was akin to almost a real political party. About half of the KKK in Oregon lived in Oregon. They endorsed the governor of the state of Oregon. The mayor of Portland was endorsed by them. They held a lot of spoils of office as well. So they were a legitimate, powerful organization. Their allure of their rituals and secrecy had a great appeal to Americans at the time. I'm just going to read one short excerpt from Margaret Myers, who's a nun who reflected on what it was like being a Catholic and a young girl in Portland, Oregon in the 1920s. The KKK was active in Oregon, especially in small towns during the years 1918 to 1924. At that time, I was a child of 6 to 12 years of age and have some vivid memories of my experience with the Klan activities. Each year, a fiery cross was burned halfway up Table Mountain, a steep hillside directly above our residence in La Grande. This was always during the late evening of St. Patrick's Day, March 17th. We assumed the timing was geared towards St. Patrick's Day, but later found out that it was only remotely related to that. It was actually the date in which the Oregon La Grande chapter of the KKK was received into the national headquarters. Several times I saw Klan members, their identity concealed under full regale, riding horseback about our streets in broad daylight. Though there was a strong anti-Catholic element behind the Klan's actions, we or I never felt any anxiety or concern at the sight, simply mild surprise and curiosity. For my parents, some relatives, and other Catholics, the Klan's machinations must certainly have been a real threat and worry. I learned that the La Grande Klan had worked diligently to have my father removed from his position as cashier of the La Grande National Bank. Their efforts failed when it was realized how much the bank might lose because of the strong support who backed my father. Quite evidently, my parents were careful to shield their children from this worry. The Klan also worked to have my Aunt Evelyn fired from her position as an 8th grade teacher in the public school across the street from our Catholic school. The reason was that the Newlands sent their kids to a Catholic school. This, of course, was tied directly to the big objective of the Oregon Klan, which is well documented in the Oregon School Bill, which we're going to actually be talking about here today. I was 10 years old when the Klan succeeded in getting the Oregon legislature to pass the bill. There was much concern that as a result, we would be attending the public school in a year or two. My Aunt Evelyn did lose her teaching position at the public school. She was then hired at the parish school to teach 7th and 8th grades at Sacred Heart Academy, where she had her twin sons and me in the 8th grade class. So kind of a world of difference maybe from what we're experiencing nowadays. So anyway, moving on with the Klan, we talked a little bit about the context there. I'd now like to talk a little bit about the context of the Sisters versus Society sister.
So, John, are you going to talk about the situation in Oregon there?
Oh, I'm sorry. My screen was frozen there for a second. I apologize for that.
Yeah, no, that's
Yes.
what, no, that's, sorry. Yeah, go ahead.
All sorts of technical issues going on here.
Yeah.
So yes, I want to talk a little bit about the context there, that in terms of the Society of Sisters, 1925, I want to talk a little bit about the ethnic and Catholic context there in Oregon. In the early 1920s, almost 95% of all Oregon children between ages 7 and 13 were in school. Most of them attended public school. There was only a small number of foreign-born people. So really this bill, this idea about a compulsory education bill, was really a herring. This really was all about eliminating Catholic schools and having a public school monopoly bill. Not too many people were worried about this. The Catholic Church certainly wanted to militarize against it, but there was a concern to the extent that they pushed back on it, there would be a lot more blowback. And there really wasn't maybe a strong desire to go all in against it because it was believed that it would fail. The Oregonian newspaper put the odds at 10-7 against it passing, but nevertheless, it did pass by a margin of 53% to 47%. So that was certainly discouraging for the Catholic population there in Oregon. I'm going to go ahead and turn it on over to you now, John.
No, thanks for that, John. And yeah, as you know, the Klan was really huge. It was this powerful force, and even you hear stories about around the same time frame, um, big confrontations in South Bend, Indiana. So this was not a Southern thing. This was pretty much a nationwide thing. In the further context of just kind of nativism and these other elements of things really played into that. So I appreciate your context there, John. I'm going to now talk a little bit about the legal context, if you will, and I'm going to kind of divide my remarks here in this portion of the presentation into three areas: some big picture legal background, the immediate legal background to the specific case, and then the case itself. So again, feel free to jump in with any questions, and John, you as well, as we look through this. But the first thing I want to start with, and this will be my final remarks, I want to start and end with this in terms of formal remarks, is the notion of the natural law. We celebrate this case, and rightly so, because it enshrines in our Supreme Court jurisprudence the rights of parents in directing the education of their children. But that's really a natural right that is ours by virtue of our nature. I think a wonderful definition of the natural law is it's the way things work, the way we work. When we procreate, we have these little children and we are to raise them, and we are to educate them, and that takes a long time. And we are to direct them to what they are made for, which is what we are all made for, is that as an ultimate union with God. But this is a notion that the ancients recognize. They recognize that we were built for something. We're supposed to act in a particular way, and acting in a particular way that it affords us flourishing and ultimate happiness is virtue. And so we see this in Cicero and Aristotle and Sophocles and that sort of thing. So this was something that people just naturally reasoned to. Couple that with its confirmation with the faith, and you have really working here faith and reason. So this is the things that the church has always taught. And it's nice to see that American jurisprudence has caught up with the church, quite frankly. A little bit more now, just extending as the church, really vivifies Europe throughout the centuries. We find ourselves fast forward to the founding of the nation, and there's really two streams of thought that go into the establishment of the United States, and in particular, its Constitution. One is the English legal tradition, which encompasses those natural law notions, but it also encompasses this development, and uniquely so in England, of what's called the common law, that moral reasoning of particular concrete of application of principle to particular concrete cases, and then seeing where they vary and how they differ as new situations arise. The biblical Christianity was always included in that, and we have our great tradition of Magna Carta and the assertion of subsidiarity with individual rights and individual freedoms really attached to the whole English tradition. So that's one big stream, and that's very important as we discuss this case in a little bit here. The other stream is kind of the Enlightenment philosophy of the 18th century, stuff that we would disagree with as being the position of the church, new ideas about the nature of man. But both of those streams were present. And so you have this kind of eclectic stew that goes into the founding of the nation with the founding generation. But I would argue that the U.S. Constitution is very much a more predominantly influenced by that English tradition, the English legal tradition, which was forged in the heart of Catholic England, really. And so what we see, unbeknownst to us, really implicit, is a tradition that was really established all throughout Christendom and came to fruition in our Constitution. Now, as we know, the Constitution has the Bill of Rights, and the Bill of Rights was originally intended to just simply bind the federal government. So by way of example, the First Amendment, in terms of the Congress shall not establish a state religion, in essence. That was not prohibited to the states. So this is what the federal government can't do, but the state governments can do that sort of thing if they want. And there's a Supreme Court case in 1833 called Barron versus Baltimore that said, yeah, the Bill of Rights doesn't apply to the states. So for a vast number of years, we did not assert at the state level individual citizens, well, I have the right to free speech and therefore I can say whatever I want because the Constitution guarantees that to me. Yeah, in terms of the federal scheme of things, but if a state wanted to have its own regulations under its own constitution, it could do that. So the notion of the Bill of Rights being incorporated to the states or being asserted against the states is a relatively recent development in jurisprudence. And it does happen, but it happens after Pierce versus Society of Sisters. Fast forward again, as we see the development of law, we have this thing called the Civil War. And we see that individuals are not being treated with respect and are considered non-persons and at the state. And so in order to take care of this, to solve this, we have the Civil War amendments, the 13th, 14th, and 15th Amendment. The 14th Amendment in particular, and I'm going to read the relevant section, talks about particular state actions, state laws, state regulations that impact fundamental rights. And permit me to read from the amendment. It says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So this is an amendment that regards state action. This will be triggered whenever the state starts to do something. And in this case, we're talking about a state law. We're talking about a law that is going to the outlawing, in essence, for all practical purposes, of Catholic education or private education. And so while the scheme of our government acknowledges the states have what are called police powers, they can regulate for health, welfare, safety, and education falls under that. They can't do things that are violative of basic fundamental rights and of what ultimately becomes the federal Constitution's Bill of Rights, or most of them. I say all this as background because this becomes the basis of the claim. When we get to Pierce, what is asserted is the liberty, life, liberty, and property of the 14th Amendment. A person's liberty is being deprived. The state is depriving them of their liberty. And due process of law doesn't just require process, as we would normally see, as the original words would say, but the court read into it kind of a substantive component. So when we talk about life, liberty, or property, what are those liberties we're talking about? What is this property notion that we're talking about? And so that's what we're going to see develop here in a second. So that's the basis of the claim, is the 14th Amendment and the due process clause within that 14th Amendment that features those elements, life, liberty, and property. Now I have to pause here for a second and say this is what I'm articulating is the current jurisprudence and how jurisprudence has developed in this country. It is still hotly debated among legal scholars as to whether or not the court should interpret the law that way. And you see these decisions in Supreme Court, and these of the Supreme Court saying, hey, we need to be originalists, or no, this is a legitimate development. That's for legal nerds to discuss. But what is interesting is the way it has developed, and again, the basis for something we celebrate rightly can have several bases, I think. But this is the way it develops. So I just wanted to provide that context. Now we go to the immediate legal background. There were a number of 19th century state law cases that ruled on parental rights. But because they were state law cases, they're based on the state law or the state constitutions, and never rose to the level of binding the nation like a Supreme Court case. And most of those cases appealed to the common law, that unique jurisprudential genius of England, that was incorporated when the colony separated from the mother country. And so we took all of their principles and incorporated it into our law. I think the only state that doesn't do that is Louisiana, because it was a French colony. It was based on the common law or the civil law. So these principles of parental oversight and directing of education is based on the common law, and there were some cases for it. There was also this case called Lochner versus New York in 1905, and this is where it goes to the due process clause. That was a case, and this is indicative of the nativists' policies that each state had, whereby the state of New York sought to regulate the bakery hours, how many hours a baker could bake. And it was kind of directed toward these immigrant bakeries who had their bakeries out of their homes, and their families were employed. And so they're paying family members. And this was kind of it was kind of an intent again to try to regulate what could or could not be one's proper running of one's business and whatnot. Long story short, the court during this era, or from 1905 on to Pierce, started protecting economic rights and judicially asserted that property or liberty were implicated by some of these strictures that are being put on by the states. And so you have this whole now 15 years, 20 years rather, coming up to Pierce, of the protection of business interests and the right to contract or the right to conduct the business in the way you want. So that's, again, the background that is percolating here with regard to Pierce. And then finally, you have, again, the seminal case, which is always seen with Pierce versus Society of Sisters, the Meyer v. Nebraska case. And Dr. James had just mentioned that. Again, anti-immigrant legislation Nebraska forbade the teaching of foreign languages, read German, to students in any public or private school. And if I can read a quote from that case, that gives a lot of context to what's going to happen 2 years later in Pierce. The court said, practically, education of the young is only possible in schools conducted by especially qualified persons who devote themselves thereto. The calling has been regarded as useful and honorable, essential indeed to the public welfare. Mere knowledge of the German language cannot reasonably be regarded as harmful. Heretofore, it's been commonly looked upon as helpful and desirable. Plaintiff in error taught this language in school as part of his occupation. His right thus to teach and the right of parents to engage him so to instruct their children, we think, are within the liberty of the amendment. And they're referring to the 14th Amendment. So let's move on to the case on the next slide. What's at issue here? What's at issue here is what constitutes liberty and what constitutes property according to the 14th Amendment. And here is a law that basically is compelling 8 to 13-year-olds to go to a public school. And that implicates the businesses. Let's talk about the property interest first. The businesses of the school sisters who've been running St. Mary's since 1859, and then this Hill Military Academy, which is a secular school, all boys school, but private. And they wanted to inculcate certain things in a military type of context. And so both of them, as a result of this legislation, totally different missions, totally different foundations, are basically being run out of business. So that's a real issue. In addition to that, of course, is the right of parents to direct the education of their children. So the liberty of these parents, the liberty of the sisters and the folks who run Hill, and their property rights are all implicated here. So the case proceeds. We have these great quotes from the case, and if you notice too, some of these decisions in this part of the nation's history are very terse. They don't get into too much detail versus Supreme Court decisions today, where you're reading 100 pages and I've already lost it, and bored to tears. But unless it's Scalia, his dissents are hilarious. But regardless, neither here nor there. There was an anecdote that happened in the consideration of this case that I want to share. one of them, or it was Chief Justice Taft, had walked into a conference room during the hearing of this case. So what would happen is that the litigants would come, they'd present before the court, and they would oftentimes retire at certain breaks and stuff like that to have a strategy session. How are we going to produce? How are we going to present this part of the case? Whatever else. Well, apparently, and I don't know if this is a breach of judicial protocol or whatnot. Chief Justice Taft, popped into one of these strategy sessions for I believe it was the litigants who were defending the sisters and Hill, and he said, "This is just simply Meyer all over again." And he said that out, and so, okay, we know what our strategy is. We're going to hammer that. And so Meyer v. Nebraska is very seminal to understanding this case. So what happened? 9-0 decision. Huge. Absolutely huge. I'm just going to go through briefly what the decision was. I'm going to turn it back over to John to give more of the context in terms of its immediate impact and implication for Catholic ed. But big picture here, as you see from this slide, the fundamental liberty upon which all governments of this union rest excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. Again, the natural right of parents and the obligation of parents to direct the education of their children is underscored and reasserted. It's a natural law right. We know this from being human persons and being made in the image and likeness of God. It's nice that the court and the common law recognize that, and now the court recognizes it as well. Likewise, underscoring the same principle, the child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. The next thing, in the next slide, the court also recognizes the police power of the state and said, look, we're not saying the state can't regulate education. It most certainly can, but in very specific and limited ways. To inspect, supervise, and examine schools. We could have compulsory attendance laws. Teachers must be of good moral character and of patriotic disposition. These are all legitimate interests of the state. Certain studies plainly essential to good citizenship must be taught. Nothing should be taught inimical to public welfare. Now, we could have a field day today as to defining those things and how that works out, and that's probably 10 more Supreme Court cases, I suppose. But it's pretty limited, and nothing that the sisters were doing or Hill military were violative of that. Finally, the court makes a final comment about the property interest of the sisters as well as Hill, in saying that the business of the schools will suffer real harm. You take away the liberty interest, the right of the parents to direct their children's education, that's going to immediately impact these schools, because who are they going to have coming to school if we're compelling 8 to 14-year-olds to attend other schools? So the reference to courts of equity point again to that English legal tradition of which we are the inheritors, and that is how the case was decided. Now, if it were argued again today, it'd probably be rooted in the First Amendment, which it is not, because again, the court in its judicial in its jurisprudence now applies the first 10 amendments, the elements that were most of the first 10 amendments to the states, but at the time it did not. So it rooted it in this due process. Either way, it comes to the point, and it's enshrined in law, and Pierce is still good law, to assert that fundamental duty and obligation of parents. That was, I think, 2,000 years of jurisprudence in about, 20 minutes, John? So I am just going to turn it over to you and shut up now and let you talk for a bit.
All right, very, very good, John. But I think, just to summarize, which is really interesting, and that is, it was argued on this property interest, that basically these schools would be out of business, and there's an interest there. But the court discovered, if that's the right term, parental rights.
Yeah.
And then fast forward now, you'd say the jurisprudence would say, oh my gosh, this is a First Amendment issue.
That's right. That's right. Yep.
So really, really interesting. Yeah. So on this slide, I've got to do some bragging here. This is Sister Bertrand Meyer. She was one of our doctoral students here at SLU back in the 1930s. The larger picture, she has a book. She's holding her dissertation. It was later published by Sheed and Ward. with an introduction written by Cardinal Stritch. And so a lot of the stuff that I'm going to tell you about was a result of her study. She probably did the most comprehensive study of the sister teachers at the time in the 1940s. So in terms of the impact of the decision, the first and most immediate impact for Catholic schools is that they could operate, right? Parents have a right now to send their kids to Catholic schools. As John might have alluded to, this is where the courts come together with canon law and the catechism, because we have two sacraments that recognize the importance of parents having children and raising them in the faith, and also recognizing parents as the first and best educators in the faith. The second impact, which a lot of times is overlooked, but is mentioned in one of those holdings of the court, was the proliferation of school accreditation and teacher certification from 1921 through 1925 and beyond. Sister Bertrand Myers here in her dissertation notes that in 1921, no state had required even 1 year of college or normal school to teach. There were literally no requirements for teachers across the country in 1921. But by 1922, a certificate was required in some states, and it could be exchanged for a high school certificate if 54 college credits had been earned, and that by 1926, all states had issued one or more certificates that developed into the vast array of certifications. So we see when the Supreme Court recognizes 1925, the state does have oversight. We see in that period, states going nuts in terms of taking a look at teacher credentialing and teacher certification, as well as school accreditation requirements. So that, I think, is a very, very interesting finding there. The third impact was this dynamic tension that now was created between the formation of teachers and pedagogical training. And that was the inherent tension that Sister Bertrand Myers looked at in her dissertation. Think about it. You know, in the time of the 1920s, religious orders were having these 18, 19-year-old girls that were going into the sisterhood, and we give them a piece of chalk and an eraser and put them in front of 70, 80, 90 little Mohicans and tell them to teach. At the same time, we want to have formation for them. And now the state is saying these 17, 18, 19-year-old girls have to go to the university state system to get teacher credentials. You could understand the concern that these religious orders had. And at this point in time, this was a real conundrum. So Sister Myers' study, she noted that the majority of provincials expressed a concern as follows. In visiting the classes of various schools, I can always spot the sister trained at the state university. There is a secular atmosphere about the room that is hard to describe, but is evident. A significant number of the deans who worked with sister teachers remarked that the instruction at such classroom, her interpretations of poetry, her approach to the study of literature were so naturalistic, even patently paganistic. That is, was not only out of harmony, but frankly antagonistic to Catholic doctrine. This is the 1940s of superiors talking about their sisters who might have been trained pedagogically at the state schools. So interestingly enough, and this fourth development is very near and dear to my heart, being a professor here at SLU, this accelerated the decision of schools of education going up at Catholic colleges and universities. So I want to just give a couple of lists here and a little bit of shout out. In the 20th century, Marquette University started summer sessions in 1909. DePaul University and Catholic University began their programs in 1911. Notre Dame was in 1918, and in 1916, so 2 years before Notre Dame, Father James Shannon at St. Louis University had Saturday sessions with the sister teachers out in their convent to give both science courses and pedagogical training. And this is how many schools of education in Catholic colleges began. It was in the 1920s or prior to that, where they ventured out and provided sister teachers with the training not only in the content, but also in pedagogy. So in terms of St. Louis University, we had our School of Education created in 1925 expressly for this purpose. So this is a quote. In the Catholic scheme, it has always been recognized that teachers who are able to exemplify and communicate Catholic culture are indispensable. A Catholic university must then not only bring forth educated Catholics, it must also apply Catholic educators. This briefly is the reason for existence of the School of Education at St. Louis University. Myers remarked that the attendance of the sisters at secular universities peaked in that 1925 to 30 period and now is definitely lower. So this is an example of where the Catholic colleges really came to the assistance of the sister teachers in terms of the training, so that they didn't have to be sent off to the state colleges. So now I'm going to turn it back over to you, John, in terms of the legal implications for today, and then I'll close it out with the other implications that I've seen.
No, that sounds great. Thanks, John. Yeah, Pierce is still good law. This is the glory of it. The bases of it, of the decision, based on the due process clause of the 14th Amendment versus the First Amendment type issue, those are debated, and the reasonable minds can differ on that. And but as the jurisprudence has proceeded, a lot of these different areas, like the economic rights theories that I talked about, being defended through the or state action being struck down through the due process clause on those sorts of things. Those sorts of things have gone away, but this one has endured. And so that's something rightly that we celebrate in this year. Now, as the years have passed, different elements or different areas of the parent's right to direct the education of his or her child have developed. And they're basically in two fronts that they've developed. Number one, the issue of parental choice, which has oftentimes manifested itself in subsidies, public subsidies to parents to send their kids to private education, private schools. And of course, Catholic schools, the largest private school system in the country. We have certainly a great interest in that. And the other front is accommodations in public schools. And by that, I mean, there things that conflict with the teachings of the church or one's faith. What can be done? Does a parent have to absolutely submit and expose his child to teachings that are inimical to his faith, or can there be accommodations given? In the most recent cases that the Supreme Court has indicated in both of these realms, the first one, Espinoza and Carson, basically the Supreme Court, and this has come a long way, and this was admittedly a free exercise clause and in terms of, or a free exercise case in terms of the First Amendment. But essentially, the court held that, look, if the state is going to dispense public funds to support private entities, it can't discriminate among those private entities. If said private entity is a religious school, then hey, and you have a scheme that's allows these public monies to go to private entities, then you have to allow the private or the religious school to be included in that disbursement. And so we see that's, 10 years ago, 15 years ago, when John and I were both coming up, as young teachers or whatever else, we would have said, wait a second, there's this notion, again, this is a topic for another podcast or another webinar, but there's this notion of the separation of church and state. And we therefore that never the twain will meet. And functionally that is so in many areas, but Supreme Court has ruled otherwise, and certainly it goes, I think, is coherent with the grand traditions of our nation from the beginning, and is certainly nuanced, but that's in terms of parental choice and subsidies. Pierce continues to be seminal in these cases, in this basic right and the subsequent necessary fallout of that, or the follow-up of that, I should say. The other area, the accommodation in public schools, this year, most recently, and many of you may have heard of this, the Mahmoud case, there was mandatory teaching of usually sexually explicit material in some Maryland schools on gay and lesbian, transgender things. And there was a coalition of parents who obviously did not want to expose their children to that. These were very small children as well. And they weren't saying that the school couldn't do that. They just wanted an opt-out. And there had been an opt-out previously, but then they standardized it and said, no, everyone had to. And the court there ruled, again, on behalf of the parents, saying this is a free exercise situation. They have the right to direct their children and form them accordingly in the education that they find most appropriate and the faith they find most appropriate. So again, this is the principle articulated in Pierce is alive and well and shows itself in these areas. And the fact that it's enshrined in precedent is a good thing because it furthers what we already know, utilizing our faith and reason, that the natural law and the faith stand as a bulwark against the encroachment of the state, which often happens. And so that is, we can judge the Constitution and state actions to a higher standard, and that would be the natural law. And of course, that is quite coherent with our beliefs. So, John, I'll let you conclude.
Yeah, I think that's really exciting, John, that you mentioned that. There's an echo from 100 years earlier. So the Pierce decision, not even looking at parental rights, right? It's looking at property interests, and then it recognized this parental right. And then 100 years later, not talking about getting rid of Catholic schools, but within the public school, that parents have this right to opt out. So
that's
really
correct.
Kind of a very exciting bookends there, 100 years apart.
Yes.
That principle created in Pierce has resonance exactly 100 years later.
That's right.
Within public school. So I just want to pick up on those kind of legal principles and echo what John was saying, that what we know from natural law and from our church teaching is now echoed here in law. And that is, just to repeat again, the church recognized parents as the first and best educators in the faith. We have two sacraments in which parents make a commitment to educate their kid in the faith, first in marriage and then in baptism. So this is what the church calls, and they don't use this term too often, primordial. This is a primordial right of parents. And clearly this is something that's recognized by the courts. The other implication is our obligation to partner with parents to provide for additional obligations. I use additional obligations here. That's a direct quote out of that Pierce versus Society Sisters decision. It's what we do in Catholic schools, right? We partner with parents because they want these additional obligations imbued in their children, that we are made in the image and likeness of God, that our destiny is ultimately not here on this earth, that we're disciples of Jesus Christ, and we have an ultimate destination that is beyond this. So really, that's, I think, a challenge to us as Catholic educators. Do we live up to this freedom that we've been afforded to partner with parents to prepare them for additional obligations? And I guess I need to take a step back and talk about this picture here. You're probably wondering who these four knuckleheads are. These four are my kids when they were in grade school at Holy Redeemer here in Webster Groves, Missouri. I'm sure my kids would be thoroughly embarrassed that I'm showing this to you, because the youngest there, Peter, is now a freshman in college. They've all graduated from college. The other three are in graduate school right now, and Peter's finishing up college. So anyway, this isn't just a stock picture. These are my four kids that attended Catholic schools. The third implication is the growth of school choice. John was referring back to when we were teachers or administrators. I was gravely concerned when I was a teacher about door after door being shut for school choice. But boy, times have changed, and particularly just in the last couple of years, with Texas getting a $1 billion school choice initiative. The tide seems to be turning in that regard. Where legislatures are recognizing this fundamental right of parents, that yes, the state has an interest in making sure that we have a literate population, but parents have that high duty coupled with the responsibility to direct that education of their children, and that they should be given the freedom of choice to make those decisions. That also puts forth a challenge for us. In years past, we could say, well, we've got this Catholic school, we don't have the resources to serve this child or so forth and so on. So that comes with an additional obligation for us today. And maybe that's the next challenge for us to really take seriously, to certainly with school choice, making it accessible for people of financial means, but also this next phase is making sure that we can serve all students, that it's a place that every child is welcomed, valued, and empowered to thrive as a fundamental expression of our Catholic identity, that we are not in a position to turn away a student because of learning differences or whatever, but truly to make our Catholic schools a Catholic school. And that's all I got. So I guess I'm going to turn it back over to Christy. I'm sure she's got some things to talk about in terms of a survey or other things like that. I apologize for the computer freezing up here. I mean, I was probably sitting there doing this, and And John's like, John, what's going on? Did you have a
Hey,
stroke there?
you weren't picking your nose, so you're good, man.
No, that's a
Fine.
good
That's
thing.
great.
That's a good
Yeah.
thing.
So
Not now, but yeah, you guys probably thought I had a stroke or something. So John had to step in and say,
no, no
John, did you
worries.
want to talk about the context there a little bit? So
Yeah,
I
yeah.
apologize for that.
No worries. No worries. Yeah.
Gentlemen, thank you. I would encourage our attendees here. Yes, I have a survey coming your way, but to pick the brains of these two phenomenal presenters here today on such a fascinating subject. So please feel free to hit that Q&A box and fill it up. Even if it's just a thought, it doesn't necessarily have to be a question, to use our time with these giants while we have them. So, thank you, gentlemen. In the meantime, thank you for this presentation here today. Riveting and so insightful on the landscape of how we got where we are today.
While
And
people might be thinking about questions and stuff, I just want to make the observation too, and John knows this, I'm sure. It's interesting. This case really has resonance, and so many different groups have marked the 100th anniversary. Just in terms of legal groups, education groups, private school advocates. It really is something that has resonance and speaks to us today. And in some of those, I would encourage anyone if, again, legal nerds love this stuff, but if you want to check it out, some of these conferences are publish their proceedings online, or you could go to YouTube and watch the different things. But the nuances and the different approaches of, hey, if this issue were to come up today and there was state action that restricted our freedom in this regard, how would what would be the strategy? How would we do it? What does it mean for our schools? It's really fascinating. And so, yeah, I don't think it's going anywhere anytime soon. And so it's the principles are timeless.
Just to pick up on that, John, in terms of the legal principles, the echo of the formation of the sister teachers, pedagogical training of the sister teachers 100 years ago, it's the same issue now today, only with lay people, right?
Yeah,
So now there's
exactly.
this tension of lay people. We're not growing up in community. You think
Yeah,
that the sister teachers had some of the best embedded professional development going on, right? They taught all day,
right,
then they came back into the convent and they
right,
had professional development right there. Lay
right.
people, we're not doing that.
That's right.
We're teaching, we're going home.
Yeah,
So just to get a shout out to SLU and also all my other colleagues in chess, the Catholic training programs for
yeah,
Catholic teachers, for Catholic administrators are invaluable.
yeah.
And so yesterday, 100 years ago, it was the sister teachers, the tension of how do we give them the professional training as well as the catechetical faith formation. Now the question is for lay people.
That's
And
right.
again, the Catholic colleges are stepping up and rising to the occasion.
Yeah, no, that's right. That's right. And I do think it is, that formation and that understanding to be deep within, deep within history and deep within the church's understanding of is essential. 100%.
And
Absolutely.
speaking of, this is perfect. We have a question here for on these cases that are such phenomenal parts of our American history for our students in Catholic schools to learn about. Do you, gentlemen, have any suggestions for resources appropriate for middle or high school students for sharing some of these legal cases?
Well, John, if you want to jump in with the
Sure,
legal,
sure.
besides shepherdizing cases or anything like that, then I'll jump in with maybe some of the historical contextual pieces.
No, that's right. That's right. Yeah. That's a really good question. There's a general lack anyway in civics education across the country generally. So if we're not reading Marbury versus Madison on a general scale, for most of our public and private school students, chances are they're probably not reading Pierce. So I think this is an opportunity actually, for especially people in the Catholic school world, because it's so intimate to us. Um, to develop materials, because I can't think of any that are, I mean, I could think of printing out the case. I can think about making a digest of it, kind of doing what I did here in terms of giving a brief, if you will, on the whole development of the law and what have you, and even our legal tradition. But I think it's a real opportunity for civics teachers, Catholic civics teachers, to form something or supplementary to a good Catholic history that talks about these era, and seeing it, as John put it, in the context of the era is essential. These things don't just pop up, right? Culture is really driving a lot of these things. So I'll turn it over to you, John.
Yeah, I'm just gonna, I guess I'm assuming the question is coming from a secondary high school teacher, civics, something like that. I think it's really exciting when you can get that prompt of the question that to the students that raises curiosity, and then the whole DBQs, the document-based question. So even raising that concern, what happened when a state tried to outlaw Catholic education, right? And then you do a quick little Google search and you can come across this little memoir of Sister Margaret Myers that was talking about the Klan and the whole bit, some of the flavor and the context. What I didn't go into while I was having my little stroke there was the involvement of the Masons along with the Klan. So this was a Klan initiative, but interestingly enough, they infiltrated the Masons, the Mason lodges, and had the Masons have a front for this whole thing. So, I mean, it's a really odd, twisted situation in the 1920s, an intriguing, exciting history. And as a high school teacher, I know you can always raise the curiosity of students by having that really bizarre question and going back to original sources and cut your students loose to learn this kind of stuff. We have a fascinating history. You know, John was mentioning ancient England. I could geek out all day long on law and natural law, the history of Catholic education in England before we got here to the United States. Phenomenal history, phenomenal stories. So I encourage you to investigate it and turn your students loose on this.
Yeah. The personalities too. I mean, these are human persons making these decisions. These are not just, these are not just principles or theories that hang in the ether. Real people are making real decisions in real time that affect millions of people and generations of people. And so I think it was at that conference in St. Louis, John and I probably should have been thinking about something like relevant to the conference, but instead we're talking about Thomas More, we're talking about the Jesuits, we're talking about the martyrs, North American martyrs. It was great. It was great. And all, so for our next exciting podcast, we should get into that stuff. So
that would be awesome.
Yeah.
Definitely sounds like a follow-up webinar topic. We welcome that, gentlemen. Thank you.
Thank you, Christy.
That would be great. Please, would like to one last call for any questions or thoughts or feedback you have, any notes of gratitude for our presenters here today. But while that's happening, gentlemen, I would like to thank you on behalf of NCEA to extend our deepest gratitude for sharing your expertise and your insight here today. And this session not only reminds us of the enduring importance of this case, but also strengthens our collective resolve to uphold parental rights and the vital mission of Catholic schools in shaping future generations. So thank you for being here with us and for sharing that. And to our online attendees, we have a thank you for being here and engaging so thoughtfully. And your input is invaluable as we work together to strengthen our service to you. In the chat, please find a survey link and take a moment to complete it when you have a moment. Thank you. And then we just see more resources on this topic. A request, gentlemen, do you have any suggestions on where to find great resources from this? We have an elementary school teacher in Tyler, Texas asking.
If you send,
fantastic.
I'll submit my, Christy, I don't know if you can do that, my email. Don't hesitate to distro my email to folks, but let me snoop around. I think there might be some places I can look, or at least put some things together that individual teachers can gather and digest themselves in presenting to the students. So I'm happy to correspond offline here and that sort of thing.
Yeah, and I think from my standpoint, it starts as simple as a Google search, but I think the Oregon History Project, it has a number of different pieces, and you can get in and see the minutes of that Masonic Lodge meeting where they put a resolution behind to go after this. There was a letter from the Catholic school superintendent pushing back against this. There was a pastoral letter from the bishop. So, document-based stuff, or even just for your own edification to go take a look at some of these resources. There's a lot of them out there. And again, I think it's not just ancient stories. As John said, these were real people making real decisions. And fast forward to today, the Mahomet decision. Imagine yourself a parent in that. I think it was in Virginia, where you have your kids enrolled.
Maryland, yeah.
Maryland, in a public school, and all of a sudden they're teaching stuff that's absolutely antithetical to your values as a family. And then at first you're given a waiver, and then you're told, nope, they must attend that.
Yep.
Wow. This last year, 2025.
Yep.
So again, this idea of parental rights, our ability to choose Catholic education, the rights that we have are just unbelievable. But we need vigilance to protect them.
Amen.
And on that perfect note, thank you. Thank you both for what you're doing. May you and all those who defend the parental rights and the mission of Catholic schools in our country, may your work be blessed. And so that we together may safeguard freedom, form disciples, and secure the future of Catholic education in this country. Gentlemen, thank you so much for being here with us today. To all our attendees, thank you as well. Goodbye and God bless.
Thank you.